We will call this Corrections Policy Committee meeting to order. Date is May 12th, 10 a.m. We are in the DPSS&T boardroom. Get the administrative announcement. This is a public meeting subject to public meeting law, and it will be digitally recorded. Deliberation of issues will only be conducted by the Corrections Policy Committee members unless permitted by the chair. Remember to always state your name for the record. For cases dealing with denial or revocation, only information contained in the staff report can be considered once the staff report is adopted. Assumptions, outside knowledge, or personal experiences should not be included in any discussion. Individuals who engage in disruptive behavior that impedes official business will be asked to stop being disruptive, leave the meeting. Additional measures may be taken to have disruptive individuals removed if their continued presence poses a safety risk to other persons in the room or makes it impossible to continue the meeting. Juan, I'd like to do roll.
When I call on you, please state your name and who you represent for the record. We'll begin with you, Chair Hunter.
Nick Hunter, representing the OSSA.
Mr. Cameron.
Jennifer Cameron, representing non-management probation.
Member Aldrich.
Josh Aldrich, Jackson County Sheriff's Office, representing the Oregon State Jail Command Council.
Thank you. Member Boda.
Margo Bowden, non-managed corrections.
Member Frasco.
Lori Frasco, Department of Corrections, AFSCME.
Member Mays.
Mike Mays, represented EOCI Corrections.
Thank you. Member Phillips.
Matt Phillips, Oregon State Sheriff's Association.
And then our newest member, Member Rice. Would you like to do your quick introduction?
Hello, I'm sorry, my camera's not working all of a sudden. I don't know why. So Greg Rice, Lane County Sheriff's Office, jail captain, member of the, or representing the Oregon Jail Commander Committee. Introduction wise, I guess.
No, and that's all that's required for
perfect.
your introduction.
That works for me. Thank you for stopping.
Thank you.
Ron works on the beach. He's a
And Member Tabor.
Todd Tabor, Professional Development Unit Administrator, Department of Corrections.
And now for staff introductions, Juan Lopez, Executive Assistant, DPSST.
Melissa Langbacho, DPSST Professional Standards Staff.
Cindy Park, DPSST, Professional Standards.
Marie Atwood, DPSST Professional Standards Director.
Victor Sanchez, DPSST.
Jason Ridgway, DPSST Training Coordinator.
Chris Enquist, DPSST Training Division Director.
Wanda Fish, Department of Corrections, BCC Program Coordinator.
And that's all for introductions. Back to you, Chair Hunter.
Excellent. Thank you, Juan. All right, we'll start with the meeting minutes. Did everyone have a chance to review the meeting minutes? If anyone needs a chance to look over those real quick, and if so, are there any questions on the meeting minutes or comments? No questions or comments. We'll just take a consensus to adopt the meeting minutes. Good to go. Good to go. Excellent. All right. We will move on to administrative closures. I believe that's what's up.
Thank you. Melissa Langbacho, for the record, Chair and committee members. The department prepared closures of 2 professional standards cases for the committee's consideration. The department is seeking a vote from the committee to approve or return the cases. Mr. Chair.
Thank you. All right, so looks like the other notes here. 2 cases are Randall Daniels and Tyler Holstrom. Without any questions or anything else, I will entertain a here. These managers, not just objection. Your consensus on this one. All right, I will entertain a motion on this one, on the administrative closures.
Matt Phillips moved to administratively close Randall Daniels and Tyler Ostrom.
Jennifer Cameron, I'll second that.
We're voting on a motion to approve the administrative closures consent agenda as presented. Chair Hunter.
Aye.
Vice Chair Cameron.
Aye.
Member Aldrich.
Aye.
Member Boda.
Aye.
Member Frasco.
Aye.
Member Mays.
Aye.
Phillips,
Aye.
Member Rice,
Aye.
and Member Taylor.
Aye.
Motion carried.
Excellent. We will now move on to our case review list. And so we're going to start with DeAndre Brown. Okay. And we're bringing him in first and
Yes.
then we'll
Juan,
do
can you
the,
go back, Mr. Brown?
Yes.
I think after you chase these over and over again, then it would just make more sense.
It's quarterly, so.
If I could remove everything else from my brain and just do this.
Lori Fresco for the record, on the last time I recused myself from this because I was part of his representation during his investigative process.
Great.
So just to continue to read this.
Strong. In a minute, we will hear the case, but before that, after we hear the case, Mr. Brown, you will have 5 minutes to share any information you would like to share for the committee members to consider during the deliberation of your case. Your time will be monitored on the clock, which will be put out in front right there. And at conclusion of your statement, you may choose to remain in the room or online, you're in the room. You will not be permitted to ask any questions or provide any additional comments for the case. Understand?
Yes, sir.
Excellent. What's that?
Thank you. Melissa Lane Batchel for the record. The department opened a professional standards case to review DeAndre Brown's arrest for reckless driving and driving under the influence of intoxicants. The department also reviewed a report from Brown that he was arrested for a violation of a restraining order on January 9th, 2025. The department previously presented this case to the February committee meeting. And at the meeting, the committee returned the case for the department to include a copy of the restraining order application in the record. The case is back today for the committee's consideration. At the last meeting, the committee identified aggravating and mitigating factors, which I'll include in the summary when we're talking about aggravating and mitigating. But for the record, the committee identified as mitigating factors that Brown took accountability for his actions and is committed to his continued sobriety by attending meetings. Brown's written mitigation included a letter from his attorney in his violation of restraining order case that indicates the underlying restraining order did not allege physical threats or injury. Brown's employer reviewed his conduct and has retained Brown as an employee. Brown has actively worked to address the issues in his life. Brown's written and verbal mitigation was mitigating. Brown was cooperative with responding officers in his criminal case. In Brown's written mitigation, he's prepared to be with his children, is committed to working on his issues. The committee identified as aggravating factors that Brown is not able to possess or own firearms or ammunition. In the DUI case, Brown's blood alcohol content was twice the legal limit. Brown had contact with the petitioner of his restraining order, which was a violation of the court's parameters. Brown's failure to abide by a protective order is a boundary issue. As a corrections officer, it's important to know boundaries. The department identified in the information moral fitness violations for the committee's consideration and found for misconduct that Brown violated criminal law and has a criminal disposition for driving under the influence after he entered a plea of no contest to the charge. Brown threatened or harmed persons or property when he operated a motor vehicle while intoxicated, and Brown threatened another person when he violated an order of protection. The department is seeking a disposition in the case from the committee. And just an additional note, since it was one of the mitigating factors. Mr. Brown, since the last review, has left the Department of Corrections. Mr. Chair.
Excellent. Thank you, Melissa. Okay, Mr. Brown, you will now have 5 minutes. Timer is right there. When you're ready.
So I had something prepared, but I'm just gonna go ahead and say, kind of towards what I had earlier. I know that I violated a restraining order, and that goes beyond what's acceptable. In my communication with the mother of my kids, it wasn't something I was trying to do from a standpoint of gaining leverage over a situation. It was more so a communicating factor, and I went outside the stipulations of what was stated in the restraining order about what specifically could be talked about, and I went beyond that. That's on me. That's my fault, and I take responsibility for that. I should have had better emotional control of how I was feeling. Despite that, I was feeling angry or frustrated about the situation. In regards to my sobriety, I did operate a vehicle knowing that I was still intoxicated, and I have done the work to get to a place where my sobriety is my number one priority, along with my kids, and taking the necessary steps to improve my mental health. I'm also back on weekly therapy sessions with my therapist, working through a lot of trauma in my life that I've gone through in my past. I am not going to sit here and say I deserve to be let off the hook, but I would love the opportunity to get to a place where I'm able to show my kids and show my family that I'm worth something and that I have a plan to get better and improve for them. So that's all I have.
Okay. First thing we'll do is there consensus to adopt this record? Okay. With consensus to adopt the record, we will move on to a discussion of aggravating and mitigating factors. I will, for the record, ask, maybe it's Melissa, but the aggravating and mitigating factors that you have previously stated, those would need to be restated in this discussion to be part of this record, or did those carry and we are now just building upon those? That's my question.
Marie Atwood for the record. We can, unless there is an objection by anybody on the committee to rescind a previously discussed aggravating or mitigating factor, we would consider those to be carried over, readopted into this set of deliberations. So unless anyone has an issue with that, that would be our plan. And we would invite additional mitigating or aggravating factors to be addressed now.
Okay, thank you, Marie. No, that makes sense. I just didn't know if, so those will carry forward in the record. Now we will go into this continued discussion again of aggravating and mitigating factors. If you are presenting an aggravating or mitigating factor, remember to state your name for the record and please clearly identify whether it is aggravating or mitigating. Nick Hunter, for the record, there was some additional staff report that was included into this record to also include the application for a restraining order. Within there, there is definitely a pattern identified of threatening behaviors over the course of 3 specific incidents. I believe November of 24, October of 24, and September of 24. So aggravating factor is the pattern of threatening behavior during those incidents.
Josh Aldridge.
Oh, go ahead.
Josh Aldridge for the record. On that note, Mr. Chair, one of our previous mitigating factors was that it did not appear the underlying restraining order alleged physical threats. So I just want to address that discrepancy that now comes up, because I agree with you that they provided that new information. It does appear that that would be an aggravating factor.
Jennifer Cameron, for the record, aggravating factors. I went back and reviewed this case. I wanted to be thorough. Regarding the DUI in 23, one of the things I saw the aggravating was that he blamed the officer, blaming him for that he could potentially lose his job and that it was the officer's fault that he was taking him into custody. Regarding the restraining order petition, I agree with Sheriff Hunter. The 3 incidences show a pattern of behavior, and while some of them may not have been physically assaultive, they were certainly psychological, and I think in many ways gaslighted the victim in this. In one of the statements from the attorney minimized it as a nonviolent person crime, and that Mr. Brown said that he's not a violent person, but yet the victim certainly thinks differently. She was in fear for herself, which is one of the reasons why the children, she was keeping the children away from him, which he made statements about what she was doing. I don't know what she was doing to keep the kids away, instead of asking himself, what was he doing? And also the restraining order violation happened after he had completed alcohol and drug treatment. So that, because that was completed, it looks like in January of 25, and then the incident of the violation restraining order occurred in January of 25. So that's all I have for right now.
Nick Hunter, for the record. Building a little bit on what Jennifer said, just providing some clarification too. So the incidents that were specifically listed in that restraining order application occurred in November, October, and September of 24. The DUI occurred in 23. So this would have been the time that Mr. Brown was either involved in treatment or trying to comply with treatment. And those incidents described in the restraining order application all involve the excessive use of alcohol. So I believe it's an aggravating factor that at that point in time, he either was not compliant with treatment or not following his treatment at that time. And kind of for the record, a mitigating factor, looking at the list, I know this mentions Mr. Brown's mitigation letter, but there were also several other mitigation letters that were received in this case file from other coworkers. One was mentioned that it was received from his attorney, but there were others received from his coworkers. Looks like the room is resting. Melissa, do you want to read back the additional?
Yes. As additional aggravating and mitigating factors for aggravating, I heard that the application for the restraining order included a pattern of threatening behavior. And it was noted there is a discrepancy between the previous mitigating factor and the current or the previous mitigating and current aggravating factors identified for that. And then additionally is aggravating in his DUI in 2023, he blamed the officer that he was being taken into custody and might lose his job. The restraining order, his conduct was psychological and he gaslit the victim. His attorney minimized his conduct as nonviolent, not a violent person crime, which the victim disagreed with and took action to keep their kids safe. The restraining order violation happened after he completed treatment. And then further, that in the restraining order application, it reflects that Mr. Brown consumed alcohol during his treatment at a time when he was not supposed to be drinking. And then for mitigating, his mitigation includes letters from coworkers and his attorney that were mitigating. Mr. Chair.
Thank you, Melissa.
Hi, Margaret Bowden for the record. I have one mitigating factor. One thing I did notice is that after his extension period, he had 1 year of diversion, which would have taken him through June of 24. His actions after that were what we're talking about now, and he actually himself extended his own diversion program to go to 25 and made that choice to keep it going. And that actually extended through the time period that he was being questioned about now. So, and that was his own action. So
That one was stated, Melissa, so you don't need to read that one back. Any other aggravating or mitigating factors? And if not, with the, I guess we're really looking at both lists. So I would say the previous list, which is now stated, and then the additional comments that were made today. Is there a consensus to move forward with the identified factors? Okay. With that consensus, we'll move on to discussion of the moral fitness violation. In this case, the staff report identified the misconduct, specifically the DUI arrest, the threat to the public in operation of the vehicle, and then also the arrest for the violation of restraining order. So I would, at this point, entertain a motion to either affirm the moral fitness violations, modify them, and if there's a modification, please state clearly what the modification would be, or to negate the violations, excuse me, the moral fitness violations in the staff report.
Matt Phillips, I would move to affirm the staff or the moral fitness violations as identified in staff.
Nick Hunter, I'll second that.
We're voting on motion to affirm the moral fitness violations as presented. Chair Hunter?
Aye.
Vice Chair Cameron?
Aye.
Member Aldridge?
Aye.
Member Bowden? Aye. Member Mays?
Aye.
Member Phillips?
Aye.
Member Rice?
Aye.
And Member T.
Aye.
Motion carried.
At this point, I will call for a motion to either take action or take no action on this case. Please state your name for the record and some supporting reasons. Nick Hunter, for the record, I'll make a motion that we do take action in this case. I think the original misconduct violation and then especially the aggravating factors that were stated in the previous discussion and the discussion today give us justification to move forward with this.
And Matt Phillips, I would second that motion.
We're voting on a motion to take action. Chair Hunter?
Aye.
Mr. Cameron?
Aye.
Member Aldridge?
Aye.
Member Bowden?
Aye.
Member Mays?
Aye.
Member Phillips?
Aye.
Member Rice?
Aye.
And Member T.
Aye.
Motion carried.
Thank you, Juan. Okay, we'll move on to a discussion of the ineligibility period. For clarification, ineligibility period, unless you can correct me if I'm wrong here, would start on March 11th of 2026. I believe that's what I read.
Correct.
So that,
Separation.
okay, data separation, March 11, 2026. So that would be the start of the ineligibility period. And we are in misconduct was the moral fitness violation. So misconduct has the 3 to 10 years associated with the ineligibility period. And I will entertain a motion. Please state your name for the record and supporting reasons for the proposed ineligibility period.
Okay, shoot, I'll go. Matt Phillips. I would propose a 3-year ineligibility period. I the DUI is certainly an issue in itself. But I think he was reasonably cooperative and not dishonest during that time. But protective orders, I think, are very serious business. And any violation should be considered very seriously. And so I think that's a starting point for me.
John Tabor, for the record, I'd second.
We're voting on a motion to impose an ineligibility period of 3 years. Chair Hunter?
Aye.
Vice Chair Cameron?
Aye.
Member Aldridge?
Aye.
Member Bowden?
Aye.
Member Mays?
Aye.
Member Phillips?
Aye.
Member Rice?
Aye.
And Member Tabor?
Aye.
Motion carried.
Thank you. Thank you, Mr. Brown. Our other in-person is online is Mr. Pratt, so we'll move to Mr. Pratt next. And Mr. Peel is not here.
It
correct?
looks like he's also here.
Oh, in that case, we can just stay right in order and we can move to Mr. Peel.
Great.
Mr. Peel, can you hear me?
Yes.
Okay. In a minute here, we'll hear the case synopsis. Once we hear the case synopsis, you will have 5 minutes to share any information you would like for the committee members to consider during the deliberation of your case. Your time will be monitored on the clock, and I don't know, can you see the clock from where you are?
Not really, but I can kind of just keep it general.
How about if we make sure that Melissa will tell you when you're at 2.5 minutes, 1 minute and 30 seconds, just so you can keep track of your time. Will that work for you?
Yeah, that would work fine.
Okay. At the conclusion of your statement, you may choose to remain in the room, or in this case, online, but you will not be permitted to ask any questions or provide any additional comments for this case. Do you understand those instructions?
Yes.
Okay. Then we will go to Melissa for, Cindy for case synopsis. That's because we switched cases back again. That's why. No.
Just keeping you on your toes.
See? It says it right there. All right.
I'll do it anyway.
Either way, Cindy, you are up.
I am, okay. Good morning, Mr. Chair, members of the committee. Cindy Park for the record. The department is presenting a professional standards case regarding correctional officer Garrett Peel. Peel was arrested on January 17th, 2025 in Ada County, Idaho for the offense of driving under the influence, second offense. A Meridian, Idaho Police Department officers responded to a collision and observed Peel exhibiting signs of intoxication. Peel provided a breath sample for testing with a resulting BAC of 0.094. Peel pled guilty to the charge of DUI second offense in the Ada County Magistrate Court on April 4th, 2025. The Oregon Department of Corrections conducted an internal investigation regarding Peel's conduct, which resulted in a letter of reprimand. The agency has maintained Peel's employment as a correctional officer. In reviewing the case, the department found sufficient information to support a moral fitness violation of misconduct. In that, Peel pled guilty to DUI second offense, a criminal disposition as defined in Oregon Administrative Rule in the Ada County, Idaho Magistrate Court. Secondly, Peel threatened harm to persons and caused harm to property by driving a motor vehicle while over the legal limit of alcohol, which resulted in Peel rear-ending another vehicle. Chair Hunter.
Thank you, Cindy. Okay, Mr. Peel, you will have 5 minutes again. We will remind you at 2.5 minutes, 1 minute and 30 seconds, should you need the entire 5 minutes so you can monitor your time. And with that, the floor is yours.
Thank you. Thank you for your time today to allow me to talk a little about my situation. On the night of January 17th, 2025, I made a very poor decision and got behind the wheel after I had been drinking. I ended up getting into an accident that I caused, which resulted in me being arrested for a DUI. Thank God there were no injuries and everyone walked away okay. I immediately knew I had made a huge mistake and that what I had done was very wrong. I was disappointed in what I did. I had embarrassed myself, my family, and my whole department. I have a problem with alcohol that am embarrassed to admit, but it's the truth. I immediately started working on getting professional substance abuse evaluation and starting class therapy. I was put on pretrial supervision, and while on that, I was monitored for alcohol and drugs. I successfully completed all tests and passed all of them without issue. I did 24 hours of substance abuse classes and completed a victims impact panel before my sentencing. After I was sentenced, I was ordered 2 years supervision or supervised probation, community service, a 1 year absolute license suspension, and an ignition interlock device for 1 year following the reinstatement of my license, and all the fines and court fees that came with it as well. Within the first 4 to 6 months, I had completed my community service, paid my fees, and passed all my drug and alcohol tests. I believe I had only had 3 tests I missed, and they were all excused due to work or not being in town. The judge gave me an option to petition for unsupervised probation after 1 year of supervised probation if I didn't mess up during that time frame. Near the end of March, I put in a motion to have my supervision to be dropped to unsupervised at the request of my probation officer. With that motion, I gave the judge the letter from my PO requesting I get taken down to unsupervised probation, a letter I wrote about everything I've done and achieved, and acknowledging what I did was wrong, and all my certifications for everything I had completed since the date of the incident. It was filed on Friday, March 20th, 2026, and approved by my judge Monday, March 23rd, 2026. After a thorough investigation through my workplace, I received a letter of reprimand, I believe in October of 25. I did report the incident within 2 days after it happened, which was on the morning of January 19th, 2025. I went straight to one of the lieutenants and they helped me fill out an F-28 form and get it submitted in time and properly to DPSST. I know what I did was wrong and I wish I could have gone back and not done what I did, but I unfortunately made that decision and I got what I deserved. By driving under the influence, I put everyone and everything around me at risk of injury and damage, and I should have known better. I've reached out to the employee assistance program through work that is available. I am getting into consistent therapy, substance abuse classes to help me be successful in my journey of recovery, and possibly doing some treatment plans as well. The past little over a year has been tough. I have realized that my addiction to alcohol has had a huge negative impact on my wife, my kids, and my extended family. Over the first year after being sentenced, it put a huge strain on my wife, parents, friends, and coworkers, all of which I had to rely on to get me to work and home. Also, during the first year of no driving, it made things tremendously more difficult to do anything with me not being able to drive my wife or kids around to where they need to go, like doctor's appointments and whatnot. I've been sober since the night I was arrested, which puts me at 480 days free from alcohol. I have a long life in front of me, and I have a family that needs me and loves me. I'm working hard to keep from the risk of losing my job, my family.
30 seconds, Mr. Peel.
Thank you. The decision I made created a hardship for my wife, kids, and extended family. Thinking about how my addiction has impacted my family has been tough. I'm an alcoholic, and with having this addiction, it has negatively impacted not only my wife and kids, but my extended family and everyone else around me. I want to thank everyone here today for listening to my story. I'm asking you to give me another chance to prove that I will learn and grow from this experience. Alcoholism is a very tough disorder and proves to be very addicting to many people, including me. Today and in the future, I'm going.
Okay, Mr. Peel, thank you for your statement. Sorry, you reached your 5 minutes is why you were muted there at the end, but thank you for your statement. Okay, with the synopsis in that statement, then I will ask if there is consensus to adopt this record.
Yeah.
Okay. With consensus to adopt the record, we will move on to a discussion of aggravating or mitigating factors. Please remember to state your name for the record, clearly identify whether it is an aggravating or mitigating factor that you are presenting.
John Tabor for the record, aggravating factor. Having a really hard time with a person on active probation supervising folks in our facilities. So active probation that's an aggravating factor for me. That's another level.
Margaret
Bowden. For the record, that it was second offense.
Yeah, and I just want to, Nick Hunter, for the record, I want to combine those two, that the active probation was because this was a second offense, which I believe would be just a separate aggravating factor in there, that this was a second DUI, not a first, but that's what gets us to the active probation.
Josh Eldridge for the record. Can I add to that, that those two offenses were within a 5-year period of time? Actually, it looks like it might be right at 6 years between the 6 years. Yeah.
Jennifer Cameron for the record. Some mitigating, aggravating and mitigating. Aggravating is that he's been arrested 3 times for DUI. Mitigating, the first 2 were when he was juveniles, or were 16 and 17 years old, it appears. Still not okay, but he was young, and even I believe now he's 24 or 25, so he's still fairly young, but still should know better. But mitigating, in his statements, I didn't hear any excuse making. He certainly did not blame others. He took full responsibility of what he did and how it affected other people, and plans to continue to, admits he's an alcoholic and plans to continue to work on that.
Matt Phillips, aggravating. This is an uncommon dishonesty issue for DUIs, but the answer of having 2 beers, I don't think would be accurate unless they were exceptionally large beers to be a point. Oh, nice.
Nick Hunter, aggravating, a little bit where Sheriff Phillips is at, but part of the investigation from DOC revolved around, or was started because of a potential dishonesty piece that existed. It came from that contact when he was originally talking to the officers on scene and denied consuming any alcohol that night. So DOC did not decide to follow up with that. I still believe it's an aggravating factor, however. The same statement was just made in Mr. Peel's mitigation, that and I'll actually read this from his mitigation letter because I believe that's where he just made his statement from. I immediately knew I had made a huge mistake and that it was very wrong what I had done. That statement is being made now when on the night of the incident, when he was first asked about consuming alcohol from law enforcement, he denied consuming alcohol. So the real aggravating factor to me, I'm sorry, Cindy. The real aggravating factor to me is that language is now included in his mitigation statement. After this was looked into by DOC, where it was already looked into as potential dishonesty, and he's basically making the same statement again, that what he knew was very wrong, yet his actions on that night, they do not align with any of that. The actions on that night align with the fact that he said he was trying not to get into trouble. So while I don't think that it is going to rise to the level of dishonesty as a moral fitness violation, I certainly think it is an aggravating factor in this discussion. And again, Cindy, I apologize.
I'll do it again.
Margaret Bowden for the record. aggravating factor for me is his pre-dismissal meeting summary. And there they state that he blew the 0.094 and then 2 minutes later, 0.091. And that he believed if he would have waited 10 to 30 minutes longer, he would have blown under a 0.08. And those are his words.
Nick Hunter, for the record, aggravating on top of what Margot just said, I think that shows a lack of accountability as opposed to accountability for the actions. Doesn't really matter when you would have blown a 0.8. The simple fact that you chose to go operate the vehicle at the time that you did is the aggravating factor.
Matt Phillips, for the record, in this case, it wasn't just that there was potential risk to injury to people or harm to property. In this case, it actually did occur. Their vehicle was damaged and the other driver complained of pain. And then for mitigating, I would say that he has committed to a sobriety and has a long term of sobriety now.
Nick Hunter and I will share too, and aggravating and mitigating. The aggravating is in his statement that he just read to us. He referred to this as an accident. This is not an accident. This is a crash. There's a significant difference between an accident and a crash. Mitigating, he did receive at least one additional letter of mitigation supporting him, I should say. Looks like from a Lieutenant Donald Harris.
Josh Aldridge, for the record, additional mitigating factor is that in the follow-up to the incident, he actually reported it in a timely manner, both to his agency and to DPSST, which is unfortunately not something we see as a common occurrence after somebody has an issue.
Nick Hunter, for the record, just because the amount of material that's on the table, I'm going to let Cindy catch up and then ask Cindy to share what she has with us.
Cindy Park, for the record. For mitigating, I have that his first 2 arrests for DUI were as a juvenile, that he gave no excuses and took responsibility for his actions. He admitted to alcohol abuse and that he's continuing to work and committed to a sobriety. He received a letter of recommendation from Lieutenant Harris. He reported the incident in a timely manner to both his agency and to DPSST. Aggravating being on active probation. It's his second offense of DUI. 2 offenses within a 6-year time period. He's been arrested 3 times. He stated he had 2 beers, but he was 0.09. And this is your Sheriff Hunter, so you'll have to correct me. And the DOC investigation investigated potential dishonesty as that he talked to officers on scene, denied any alcohol intake, and the language in his mitigation statement stated otherwise. Pre-dismissal meeting, he stated if he would have waited a period of time, he would have been under 0.08, which shows a lack of accountability. There was harm to property and a driver, and it wasn't an accident, it was a crash. Chair Hunter.
Thank you, Cindy. Any additional aggravating or mitigating factors anyone would like to contribute to the record?
Lori Frostman, for the record, I would say for mitigating that he did complete all his requirements of the courts and appears to be in a timely manner and also got reduced from active probation to inactive probation early. Actually, copy that. And another mitigating is he does still maintain employment with the department. Letters of support from this.
I think Those two are stated, Cindy, so you don't need to read those two back.
Thank you.
With the aggravating and mitigating factors that have been shared, is there a consensus to add those to the record? Okay.
Yes.
Seeing a consensus, we'll move on to a discussion about the moral fitness violation categories identified in the staff report. In this case, the moral fitness category that was identified was misconduct involving the criminal arrest, and then the threatened harm to other people, the actual crash, and it being a second offense. I will entertain a motion to either affirm, modify, and if it's a modification, please clearly state why, or negate the moral fitness violations as presented or identified in the staff report.
Josh Aldridge for the record, I would move to affirm the moral fitness violations as stated in the staff report, specifically misconduct.
Mark Bowden for the record, I second.
We're voting on motion to affirm the moral fitness violations as presented. Chair Hunter,
Aye.
Vice Chair Cameron,
Aye.
Member Aldridge,
Aye.
Member Bowden,
Aye.
Frasca,
Aye.
Member Mays,
Aye.
Member Phillips,
Aye.
Member Rice,
Aye.
and Member Tabor.
Aye.
Motion carried.
I will now call for a motion to either take action or no action. Please clearly state your name for the record and supporting reasons for taking action or taking no action.
John Tabor, for the record, I'd move that we take action or recommend take action based on the aggravating and mitigating factors as they were stated.
Mark Bowden for the record, I second.
We're voting on a motion to take action. Chair Hunter,
Aye.
Vice Chair Cameron,
Aye.
Member Aldridge,
Aye.
Member Bowden,
Aye.
Member Frasca,
Aye.
Member Mays,
Aye.
Member Phillips,
Aye.
Member Rice,
Aye.
and Member Tabor.
Aye.
Motion carried.
Okay, we'll move on to a discussion of the ineligibility period. And Cindy, if you could clarify, I believe ineligibility would start with the board decision in July of 26.
Correct.
Okay. In this case, the moral fitness violation that was identified was misconduct. Misconduct has an ineligibility period of 3 to 10 years. I will entertain a motion of a proposed ineligibility period. Please clearly state your name for the record and reasoning for that proposed ineligibility period.
Josh Aldridge for the record, I would propose the minimum 3-year ineligibility period. And the reason for that is while I believe that this case it is appropriate to take action, I do see that steps are being taken that can hopefully help lead to some success later in life and would encourage him to continue along that path after the ineligibility period.
Dick Hunter, for the record, I would second adding on to what Josh has said. I believe the 3-year minimum is appropriate. However, the aggravating factors in this case, while I do appreciate that Mr. Peel is starting to move forward and taking steps to move forward, this is a situation which should have accountability involved. His actions, while in this case no one was injured, significantly put risk to the public. And so I believe those aggravating factors outweigh the mitigating for this board's action. That's why I second the 3-year ineligibility period.
We're voting on a motion to impose an ineligibility period of 3 years. Chair Hunter,
Aye.
Chair Cameron,
Aye.
Member Aldridge,
Aye.
Member Bowden,
Aye.
Member Frasca,
Aye.
Member Mays,
Aye.
Member Phillips,
Aye.
Member Rice,
Aye.
and Member Tabor.
Aye.
Motion carried.
Thank you, Mr. Peel.
Thank you.
We will move on to our case today, which is Jacob Pratt. Jacob, I see that you are online. Can you hear me okay?
Yes, sir.
Okay. In a minute here, you will hear the synopsis of your case. Once you hear the synopsis, you will have 5 minutes to share any information you would like for the committee members to consider during the deliberation of your case. Your time will be monitored by the clock, and I'll ask you the same question. Are you able to see the clock if we put it in the middle of the table, or would you like us just to give you the times?
Oh, just give me the times. That's fine.
Okay, we'll do the same thing, the kind of 2.5, 1 minute, 30 seconds. I apologize for the interruptions when I do that, but I'll try and at least keep you on track. At the conclusion of your statement, you may choose to remain online, but you will not be permitted to ask any other questions or provide any additional comments for this case. Understand those instructions?
Yes, sir.
Excellent. And this one is going back to Melissa. And so Melissa, the floor is yours.
Thank you. Melissa Langbach for the record. The department opened a professional standards case after receiving notification from the Multnomah County Sheriff's Office that Jacob Pratt had resigned on October 29, 2025. Records from Multnomah County indicate that they conducted an internal investigation to review Pratt's long-term use of his long-term absence from work on an unpaid status. Pratt had exhausted all of his FMLA leave options and was unable to find a paid leave option for his away. Pratt resigned prior to the investigation, sustaining findings related to his use of unpaid leave for several months. The department presented the case at the February Corrections Policy Committee meeting as an administrative closure. At the meeting, the committee requested the case be returned for a full review at the next meeting. The department didn't identify moral fitness violations in the case and is seeking a disposition from the committee on the case, Mr. Chair.
Thank you, Melissa. Okay, Mr. Pratt, the floor is yours, and your 5 minutes starts now.
Okay. Just a few months back, I didn't know I was diabetic. I ended up going into what they call a DKA, diabetic ketoacidosis coma. And so I had to be admitted to the hospital for over a week. And then I was readmitted 2 different times after that, up until they could sort out my insulin treatment. I couldn't maintain stability or walk. And so after just being admitted for so long to the hospital, and I was reaching out constantly to let them know, but like, even in the paper reports that I have here, it says dishonesty. The department did not identify elements of dishonesty, misuse of authority. The department did not identify elements of misuse of authority, misconduct. The department did not identify elements of misconduct. Before I found out I was diabetic, I had what's called like a DKA. It's diabetic ketoacidosis. So they had to induce a coma on me, basically keep me alive. I stopped breathing twice. And even right now, I still have to use a wheelchair some days to get around. I reached out to the agency pretty much every day to touch base with them and let them know where I was. But was it kind of ran up the chain of command? They just kind of got, I believe maybe they just didn't want to hear it anymore. So they told them to just let me go. And I even requested potentially going on light duty or anything like that, or potentially lateraling to an administrative job within the jail. But at this point, I am registered as a stage 2 diabetic, and I haven't known it up. Thank you. And yeah, so after that, I ended up suffering 2 more DKAs, and getting readmitted 2 more times to the hospital after that. So after the first week, I got admitted for another 5 days. Then after I got readmitted for another like 3 days, something like that. So I ended up getting the call that they're just like, I think it's just, we're just gonna let you go, which I think is a violation of the medical condition that I was personally trying to sort out and accumulate. And so now I'm recently on insulin, and I'm getting around, I'm moving a lot better, but the agency wouldn't have me back. So I would like to retain my DPSST so I could potentially lateral and go somewhere else now that I'm appropriately medicated due to my diabetes. But they're basically short-term there's basically short-term diabetic comas, and I had multiple of them back to back, which caused me to miss.
Mr. Pratt,
Thank you.
with the case synopsis and the mitigation provided by Mr. Pratt, is there a consensus to adopt this case? Looks like a consensus on adopting the case. Mitigating factors. Please remember to state your name for the record and clearly identify whether this is an aggravating or a mitigating factor that you are presenting.
Jacob Lee Pratt, and I would say.
Excuse me, Mr. Pratt. Once you provide your statement, you are no longer permitted in these deliberations. These deliberations are for the committee only. You can certainly remain online and listen. You can just no longer participate.
Matt Phillips for the record, Mr. Chair, this isn't really mitigating or aggravating. This appears to be a case where the county and employee were navigating FEMLA, OFLA, paid leave, Oregon, ADA accommodations. And I don't know that we have real insight to that process, nor should we. Certainly it raises eyebrows when but at least in the record, I didn't see anything that necessarily indicated dishonesty or a moral fitness violation, but maybe a lack of communication, which is probably more of a policy issue for the agency and the employee to
aggravating mitigating road here. So the reason that we had originally asked to see this whole case was the fact that Multnomah County had an open investigation at the time that they separated with Mr. Pratt. And the concern was that there was something else that was involved in this separation other than the time loss issue that Mr. Pratt is going through. So I agree with Sheriff Phillips in that. And so you may get mad at me, but so I think to make this easiest at this point, I'm just going to ask, is there anyone that would like to put an aggravating or a mitigating factor on the record, or are we good on consensus to move forward to step 3 and the moral fitness violations and have that discussion?
Good with moving on. I think we should move forward.
Same.
Okay. So there's my consensus there. So now we are at the moral fitness violations categories. If everyone remembers, this was originally brought to us as an administrative closure because DPSST in the staff report was unable to develop any moral fitness violations to meet any of the categories, whether it be dishonesty, misconduct, or misuse of authority. So at this point, for us to move forward, I would need to entertain a motion either to identify a moral fitness violation that we could move forward with, or negate. And if there was a motion to negate, it would be that there is no identification of moral fitness violations in this case.
John Tabor, for the record, I would move to negate.
Josh Aldrich, that's second.
We're voting to negate.
Hang on just a minute. I'm sorry, Nick Hunter, for the record. I may have not said that correctly because I'm not sure if Member Tabor is not just affirming DPSST's not finding a moral fitness violation. I think negating would be the opposite of what I was actually trying to accomplish. So I'm gonna let Member Tabor modify his.
So the motion then would be to affirm the lack of a moral fitness violation.
Yes.
Okay, I so move.
Josh Aldrich, I will second.
Thank you, sir.
Sorry.
All right, so we're voting to affirm the lack of a moral fitness violation. Chair Hunter.
Aye.
Vice Chair Cameron.
Aye.
Member Aldrich.
Aye.
Member Bowden.
Aye.
Member Frasco.
Aye.
Member Mays.
Aye.
Member Phillips.
Aye.
Member Rice.
Aye.
And Member Tabor.
Aye.
Motion carried.
Kind of for the record. So now that we brought this to this point, do we need a motion to take no action in this case based on no identification of moral fitness violations?
If there was a, Maria, for the record, if there was a violation identified, then the next step would be action versus no action. But in light of there being no violation identified, no further actions required.
Thank you for the clarification. Okay. Thank you, Mr. Pratt, for your time.
Thank you, sir.
And we are now going to move on to number 7, Anne Marie.
Thank you very much, Chair. Marie Atwood for the record. Agenda item number 7 is committee nominations for the applicant review committee. So we have, beginning tomorrow, a vacancy on the applicant review committee where member John Frost, who was previously part of this committee, was serving. So his term ends tomorrow, May 15th of 2026. We therefore, because he is no longer a member of the Corrections Policy Committee, he served both of his terms, need a brand new member. So the administrative rules that govern the applicant review committee require that anyone nominated to serve has to be a current member of policy committee. So that means that we need somebody from this group here to either self-nominate or to be nominated by their peers for the applicant review committee process.
Question for you, Jeff.
Yes.
Can you just inform us, remind us what that entails?
Yes, the applicant review committee is the committee that deliberates on cases involving pre-employment misconduct. So if someone has criminal history that predates their employment as a public safety professional, the applicant review committee would review that conduct and determine whether or not to allow them to even proceed into the career path or to establish an ineligibility period that would kind of prevent them from entering the police academy, for example. The applicant review committee, because those decisions need to be a little bit more timely, if, let's say, an agency wishes to hire on an employee, but during the course of their background check, it's learned that there is criminal history present, rather than have that person wait for a quarterly decision to be made, the applicant review committee traditionally meets once a month. The meetings are obviously in person or virtual, tend to be quite a bit shorter than the average policy committee meeting, and have a lot less volume of material. Sometimes, right? All of that can be subject to the various complexity of each case. Any questions about the applicant review committee process?
What days do they meet?
Excellent question. Juan, do you happen to have when the next date is?
So This month's meeting was canceled, so
Yeah.
it's the third Wednesday of a month, so, around.
Yeah, about June. It's probably.
I feel like that's kind of a teaser one to say this meeting was canceled. Like,
It's workload at all.
We do see a lot that it gets canceled, but that's why I was like, with the workload, and then do they have morning meetings, afternoon? It's
11 a.m.
11 a.m. Yeah, so the next meeting is June 24th at 11 o'clock.
It's the limits of the term.
Yeah, so it's a single year term, but the person can serve twice. I think, or is it 2-year terms?
So that's the question that we were having.
Hold on, I can look up the OAR. The term of an appointed member is for 1 year. An appointed member may be appointed to a second term.
the third Wednesdays.
Yes.
And this is formed for like when somebody does the application and the actual agencies themselves do the background check, and if this comes up, and then it goes to them to decide whether or not they should allow this person to continue the process?
Right. So typically, the information would arrive to us on an F-28 form. When someone has been hired by an agency, wants to begin with basic training, the committee has to decide whether or not that's an appropriate step to allow them to take.
And I'm assuming that because most agencies, some would just automatically, I would think, not proceed with sending them through the academy if they'd already seen certain things. So these are people that potentially may not fall into.
Yes, that's an excellent question.
Clear.
Right. So you're correct. A lot of times, many agencies, when they learn of criminal history, may decide not to hire that individual after all. It's only those cases where they want to hire someone on and let them proceed with the academy process that the ARC team would deliberate on those.
Josh Eldridge, can you describe the makeup of the board? I know you said this position needs to be a sitting member of the CPC, but like, what's the board made up of?
Excellent question. Marie Atwood for the record. So the ARC, the Applicant Review Committee, consists of 2 members from each of our public safety policy committees. So 2 members from Police Policy Committee, 2 members from Corrections, 2 from Telecom, and 1 member of the board. So, and it must consist of those members. And the quorum required for the ARC to meet and deliberate is at least 4 members must be present. There right now isn't an active vacancy, so the board seat we also need to fill the next time the board meets, assuming there are nominees. And just as a matter of notice, the other member currently serving on behalf of the Corrections Policy Committee is Mark Boren. His term for the Applicant Review Committee does not end until November. However, as you probably recall, his term on CPC recently ended. So not only do we need to fill the first Corrections Policy Committee membership for ARC today, hopefully, we will also need to fill another one in November.
And will that person have to be on the board? You said there has to be one person from.
Yeah, because
one representative.
when he became part of that applicant review committee, so
Right.
yeah. So I'll be nice. I'll take seat number 1 if I don't hear a whole lot of people saying, let me please do this. So I'll take seat number 1, but then everyone else needs to be ready that come November, there's going to be seat number 2 that's also going to come up.
That's what I was wondering. Does the seat number 2 have to be someone's on the board? Because I am on the board.
It has to be someone who's in this committee.
Okay, doesn't matter on the.
Correct.
Okay, that's what I'm saying. I didn't know if it was the DCC board, so I was just verifying that.
Yeah, the board has its
Somebody needs to
own
have its
specific.
Okay.
Mr. Chair, I'm willing to take this spot. And the reason I say that is because I think I'm in my last term here. So I could probably only do this a single time, I believe, before I would time out of the CPC. So if you would prefer, I could take this one and leave the November one open for somebody who's got a little longer time on the CPC remaining.
Well, I'll amend my self-nomination, Josh.
I thought you'd be.
I appreciate
amenable to
that.
Yeah, I'd be happy to serve. It would probably just be the 1-year commitment, I believe, because I don't think I have enough time quite for 2 full.
That is Marie Atwood for the record. What I have listed as your expiration date for Corrections Policy Committee, Member Aldrich, is April of 2028. So you would be right there on the edge of being able to serve almost two full terms. But
Yeah, I'll put myself out there for a nomination.
Second that.
hey,
We're voting to nominate Josh Aldridge to the applicant review committee. Chair Hunter.
Aye.
Chair Cameron.
Aye.
Member Aldrich.
Aye.
Member Bowden.
Aye.
Member Frasco.
Aye.
Member Mays.
Aye.
Member Phillips.
Aye.
Member Rice.
Aye.
And Member Taylor.
Aye.
Motion carried.
hey, thank you very much, Member Aldrich, for volunteering for that nomination. We appreciate it.
All right, we are moving on to DOC. Does anyone need a break?
Yes, I was just.
Okay. We will take a 5-minute break.
from that email? Is that why Jason left?
No.
Okay. EMS reporting to the campus. Uh-oh.
To all of our members online, we returning.
You snacked up and ready?
Yeah.
So we'll go back on the record and let 22 or whenever one hit the button.
Oh, we're already on.
And that means we're moving on to DOC request for Correction Policy Committee approval on a pilot of revised correction course BCC. And it's going to be Member Tabor.
So John Tabor for the record. Thank you, Chair, Co-Chair, for having us. Over the last 2 years, we've been working in DOC to bring our basic corrections course curriculum in line with the changes that were made to the BCL back in 2024. It's been a major undertaking for a very small team, as you guys can relate. You guys made these same changes a couple years back and struggled mightily through that, I know. So what our ask for the committee is authorization to pilot the updated program starting in July. We'd like the opportunity to pilot it so that we can get a good look at our curriculum, make sure that it works and flows the way we want it to, make adjustments through the end of the year. And then our goal would be to come back around the end of Q1 or maybe in Q2 next year and seek permanent approval to move forward with the updated program. The program currently is what it has been since 2009, essentially. It's been tweaked and adjusted and polished and moved a little bit, but by and large, it's built on the bones of the same corrections academy that I attended in 2001. It doesn't meet our needs. So this is a major full-scale rewrite, a huge increase in the focus on communication, de-escalation, emotional intelligence, trauma-informed care, gender responsivity, things that our old program just didn't include. It's also a much more adult learning centered model. Our current model is block training, 2 weeks of death by PowerPoint, followed by a couple of weeks of application. This program has application early and throughout. So there's a major shift in the delivery mechanism in this new program. All of the curriculum is not 100% ready to go. It would be by the time we roll out in July. There are significant parts of it that will be carried over from the existing program. Our use of force curriculum, as an example, isn't going to change in any meaningful way. Our communication stuff will. So the interleaving of that training from day one focused on some core competencies. Those will be echoed in every class throughout the rest of the 7-week program. One of the things included in the information we provided is an hourly comparison, BCL and BCC. BCL is a 240-hour course. BCC will be a 256-hour course. The reason we have those 2 additional days is we also train our staff with rifle, shotgun, and for mobile patrol. And we just extend those 3 days into a full week, grab 2 more days of training for our staff, which is why we're at 256 instead of 240. There is a ton of information in that 45-page document that was provided. Essentially, it demonstrates how we are aligning our new program with the 2024 changes here. It's a lot more competency-based and a lot less focused on how many hours you're doing things. So that's our big ask. Does the committee have any questions?
Matt Phelps, for the record, I support the concept. What I don't support and find difficulty with is the wisdom in having an OAR that is so restrictive and prescriptive that you're not allowed to change with the times.
Yeah.
And how do we get that updated so that your agency has the flexibility to update its training to best practices?
Yep. So one of the asks for John Tabor, again, for the record, one of the asks that we will come back with is OAR change language. So that's not included in the pilot. There were changes made to the OAR to allow for the BCL rewrite. There was a shift there. And then all of the kind of the old legacy language was left in the OAR so that we could continue to operate our existing program. There are going to have to be some changes to the OAR for us to come in line permanently with what DPSST is doing. I think if you look at some of what we're going to propose, it is opening some doors for some flexibility for that exact reason.
Nick Hunter, for the record, no, John, you hit some words that I like. Interleaving is a big one. Focusing on the science of learning, human performance. This is where a lot of these need to be updated. A lot of our courses, I know DPSST focuses on that too. So I do support this. I do support also what Sheriff Phillips just shared. I'm going to go a little bit crazy Ivan here. And what I would like to do is if we can put a pause on this motion, I would actually like to hear from Chris first on the DPSST supporting side of it, and then we can put those two motions on the table if that's okay.
Great idea.
Not to put you on the spot.
I'm ready.
Chris Enquist, Train Division Director for the record. I'm here speaking both for myself and for Jared Rayburn, the Dean of Students who oversees CPE. And you'll see before you just a memo that serves two purposes. One, we are technically asking for the CPC's approval to support DOC's pilot. That is an action that we probably could see our path to just seeing within our normal operations. But I thought, just given the unique relationship with DOC's conducting a basic training outside of our organization, it was worth just highlighting what that support might look like and to kind of seek your formal approval to do so. I'll just speak to it briefly. I think John spun it up really well. His documents certainly articulate a really well-designed program. It's been a really effective collaboration. So about 2 years ago, right about as the 2024 BCL implementation kind of started to come into effect here, John and I and other staff at DPSST started to integrate and really start to take a second look at what does that audit function of DPSST look like against DOC. Those that have been around will remember, if you go back 5-10 years ago, it was a very structured paper audit that was very focused on were the students in class for 2 hours. Did the instructors use, this slide in this PowerPoint? Did they speak to this learning outcome? There's a value in that kind of monitoring. It's been really nice over the last 2 years. We've kind of morphed that process into one that's a lot more collaborative. It's taken the form of us pushing instructors to DOC for BCC when they're running programs. And while we're certainly auditing what they're doing, more often than not, we're kind of teaching alongside them or just side seating with instructors. And it's given us a much better view on the actual instruction given rather than just kind of the checkbox audit that we were previously doing. That's been a core part of how we've supported their development, and it's likely to be kind of the main thrust of how we support the implementation of pilot. Continue to identify staff that work here, teaching in basic training by skill areas and partnering with DOC as they run these pilot courses, as much to assist as to learn. I think one of the best things that's come out of the process we've engaged with over the past 2 years is just a nice shared realization for both DOC and DPSST that like both entities are providing quality training and there's room to grow and learn on both sides. I think how DOC is running their scenario training program in some ways is better than how we're operating training here for BCL on campus. And we've taken action to kind of try and take those lessons and apply them in how we learn. And there's plenty of places where we're happy to offer technical assistance to DOC as they continue to implement. So it's a bit of an open-ended process other than the timeline John laid out in terms of how many classes would run under pilot. But for the duration, DPSST is more than prepared to kind of step up and continue to put resources there to support DOC. I'm happy to take any questions.
Hearing none, these are all going to require motions, correct? Or
Yes. Every item, Marie Atwood for the record, basically for the rest of the agenda would require.
That's what I thought.
Yeah.
Okay, so I will go back one now, and I will entertain a motion for Member Tabor's request on DOC's request for Correction Policy Committee approval to support the pilot of revised correction course or BCC.
Mario Bowden, for the record, I second it.
Did you say second?
Second. You made the
Oh,
motion.
you made the motion?
No, I just made it really easy for someone to say, so moved.
Yeah.
So
moved. Second.
Second.
there we go.
We'll get there.
We're voting on a motion to approve the DOC request as presented. Chair Hunter,
Aye.
Vice Chair Cameron,
Aye.
Member Aldrich,
Aye.
Member Bowden,
Aye.
Member Frasco,
Aye.
Member Mays,
Aye.
Member Phillips,
Aye.
Member Rice,
Aye.
and Member Tabor.
Aye.
Motion carried.
All right. Nick Hunter, for the record, I will make a motion that we provide approval for DPSST support of the pilot of revised basic corrections course BCC curriculum.
Josh Aldrich, I'll second.
Jennifer Cameron, I will make the first motion to go with the approval of DPSST to support the pilot project as stated by Chair Hunter.
Put your verbiage. Put your verbiage.
Who made the motion? Just because I'm gonna write minutes.
I made the motion to try and make it easier. Yes.
Confusing.
I know. I went in the opposite order. So I think we satisfied it with, I had the motion, Josh seconded it, and we will take into consideration Jennifer's comments of support for that motion.
We have a motion on a second to approve the DPSST support of a pilot of revised basic corrections course curriculum as presented. Chair Hunter.
Aye.
Vice Chair Cameron. Member Aldrich.
Aye.
Member Bowden.
Aye.
Member Frasco.
Aye.
Member Mays.
Aye.
Member Phillips.
Aye.
Member Rice.
Aye.
And Member Tabor.
Aye.
Motion carried.
All right. We will move on to criminal justice fee implementation, and that is Chris again.
Happy to be back. I'll start off with a bit of transparency on this one. Well, I do have a motion or an action item for you. Often I come to the table for policy committees or the board with a firm recommendation, and this is a challenging one. So I'm not going to, I certainly have a recommendation, but it is a soft recommendation, and I'll talk you through the why on that. So DPSST, I believe we presented direct to the board last cycle on the concept of fee implementation. This is driven by two factors, and there's two separate types of fees. So I'll just overview those if you didn't have a chance to review the materials. The first would be a facility use fee. As many of you know, right, the campus exists here and it is used by external constituents. While DPSST is considered fees related to allowing external partners to use the campus repeatedly over the last 20 years, we've never implemented. There are a number of issues with the campus in terms of deferred maintenance and aging and wear. And while the current process, if you're an external agency and you utilize the campus, you sign a use agreement that certainly says if you break a window, right, you're going to pay for that window. It offers no kind of collection point for just that kind of general wear and tear. And so I think the best example of a facility that we're concerned about would be the track. The track gets pretty heavy use by external partners. It is going to be a sizable cost when the bill comes due for maintenance on that or some kind of resurfacing. And it led us to consider, like, should we be pausing and thinking, a nominal fee for use of campus facilities? Memo kind of articulates the volume of use. Campus facilities are used pretty heavily by external partners. Let's draw a line there. So that would be facility use on this campus for external partners. The second fee that came to the table in this conversation was one related to regional training. Regional training, as most of you are aware, right, operates training off of this campus around the state, generally at low or no cost to constituents or partners. Currently, the only kind of in-kind fee for attending those programs is we now require and have for the last 4 years. If you're attending a firearms program, the first expectation is that the employing agency will provide ammunition, and we have a process built in where they can submit a memo to Jim Sully, who runs that program, to waive that and will provide ammo, compared to how it was 10 years ago, where DPSST always supplied ammo. Other than that, there's no cost. The challenge out of regional that led us to fees wasn't necessarily one of like wear and tear or operational cost, but rather one of late cancellation or no-shows. So when we stand up like a handgun instructor program in Ontario, like we'll be running in a couple of weeks, and we ran last year, that becomes a real challenge when people no-show. We cap those classes for sake of argument. We'll say, if we have a handgun instructor class in Ontario capped at 12 students, That's going to drive our staffing, right? We'll probably staff 4 instructors for a program like that. We are putting them on the road, securing lodging. We always have a wait list for most of these programs. So we have 12 people rostered. We probably have 18 more on a wait list, and our staff show up in Ontario. And what do we have? Eight students, 6 students, 7 students show up, and the rest are no-shows. We're at a point then where it's not really cost effective for us to staff down, right? We can put people back on the road, cancel hotels, but most of the cost we're bearing in that is in their hours and in their time traveling, which isn't really recoverable. And the real burn is we've got a slate of 12 or 18 other people that wanted to get into that class that now are on the hook for us for the next class. That no-show, I have some data that it's been slowly ticking up, and it's just becoming a point of frustration where we're running at a loss, essentially. The first draft of this that came out that we presented to the board, we were proposing a slate of, I would describe them as nominal fees for the facility use, $50 a day for a classroom venue. The peak would be $200 a day for the track. On the regional side, we considered just a flat registration cost. Everybody pays a registration cost. That avoids a need for a deposit. Everybody pays in, and it helps us kind of balance out the cost of those no-shows. This is a good pivot to talk about feedback. So feedback internally from the agency, we also conducted a survey. I gave in the materials kind of a summary of the survey results. And as you would expect, constituents are not excited to pay a fee in any form, and for good reason. And so we reconsidered the fees. We brought them down to the numbers I just listed there, and we changed the regional fee. Rather from a registration fee, we laid it out as a $100 per incident student absence fee. We feel better with those, but this is probably a good transition into why I have a soft recommendation. The survey results, well, they weren't overwhelmingly negative. There were several things brought up there that we've discussed at the leadership level and the training management level that really get at the core of what our mission is. There were several comments in that survey that just kind of suggested, like, what is DPSST's mission, if not to provide training at no cost to constituents? People brought up kind of the past historical about how we're funded, the transfer of CFA funds. Those resonated with me and with members of leadership. And I think I would like to just put before you a pretty transparent ask of how does this policy committee feel about the concept of fees generally, or either of these fee options? The one extra caveat is your feedback would be brought to the board alongside that of Telecom Policy Committee and Police Policy Committee. The board's direction to us was go to the policy committees, get their feedback and recommendation, and then come back to report. Process from here, just note that implementation of fees takes time in the state. So a yes vote here, even a yes vote at the board, would simply just trigger a process that while we could, would presumptively go through the normal legislative tracking, there is a possibility we could seek a way to kind of shortcut that, still through legislative process, but kind of do it through a different means. But still, we're talking, 9 months a year down the road from board approval before we're really at a place of implementation. I don't want that to mitigate your decision though. So I'm happy to answer questions about this if there are any.
Matt Phillips, I have probably quite a few questions that would help inform me on my either support or not. But first, what would be the anticipated revenue annually from these fees?
Yeah, that's a challenging one to answer. When we look at how we collect data, particularly on the no-shows for regional, it would be pretty nominal. Now that we have it set as an absence fee, we're probably talking somewhere in the neighborhood of 40 to 60 absences in a year at the max. So it's a pretty nominal recovery. That money would be retained within the operational budget of regional training, really to offset use of part-time instructors.
Those absences primarily in your more rural frontier areas, or is it uniform throughout the state?
It really is. What's challenging is yes, and yes, I guess. We see absences at pretty much every training event we run, but largely driven by that backlog we have in people seeking training. When we might be offering a handgun instructor program in Ontario intending to meet local need, and yet we'll have 3 students from the west side of the state enrolled there simply because they're looking for the next available class. So it gets to be a little hard to pin down where the absence is being driven from when the patient within 72 hours prior to program would eliminate any imposure of fee, as would we still carve a path on both fees for agencies to submit a hardship waiver. On the campus side, that's a little easier to contextualize, I guess. What gets hard is some of the data we have on the background becomes a little murky. We have, I think I noted in the memo, well, there's only about 200 to 300 facility use requests processed in a year. Many of those are for multiple days of training. So Salem Police is a perfect example. They'll submit a single use request but it might be for 12 days of track use, if that makes sense. So digging deep on that to actually gather what the revenue would be becomes a little challenging because those kind of ebb and flow year to year in terms of how agencies are running training. But we're probably talking in the neighborhood of, I have it listed as 1,200-ish training events. If we average that out to $50, we're not talking a significant amount of revenue.
And Matt Phillips, would this revenue just go to the state general fund, or would it go to a specific bucket for the maintenance of this facility?
The current view on this fee, if imposed, and what we've gotten from fiscal, would be that it would be retained by the agency and it would likely land with the administrative services division, right? Facilities types of campus.
And speaking of the track, I'm sure it's built to the same standards of any nice county road, things like that. And so while it's 27 years old, it really doesn't get that many miles driven on it compared to the daily traffic anywhere else. So is the wear and tear on it more environmental, or is it because the police cars are actually destroying it?
It's a combination of things. The miles is certainly one way to measure it, right? And there are a lot of miles logged on it, but you're right. It's not the same as Highway 20, Highway 22. Its core specs are different. It's built to ODOT spec in terms of road grade and design, but the underlying design on it is substantially different, particularly on the concrete portion. It's rated out where we could opt to operate like a fire apparatus on it. So it has like a much more substantial underlay. Wear and tear is tricky. I do think how we train and the way we operate vehicles on it probably is creating some wear, particularly on the asphalt side of the track. But there is a lot of it that's probably environmental. It's just simply a road that's been in place for 20 years. Specifics on track, I don't have immediately available beyond like anecdotal. That will be lumped into a facility condition assessment that'll be completed over the next year.
The Canadian Geese are heavy users of the track.
Very much so.
Charge them anything.
You're welcome to recommend that we can do a goose fee in lieu of this.
Yeah, Nick Hunter for the record. I'll echo the other elected official in the room that started talking about state budgets. Couple things, and Chris, you may want to elaborate on this a little bit more about the deferred maintenance and the 2% minimum. And the 2% minimum has become the 2% standard and what that looks like. So as a agency that lives 5 feet away and uses this facility, I think that where some of this starts to get lost is business need. And if you look at some of the survey results, if you send me a survey and ask me if I want to spend money, I certainly do not want to spend money. We are all working under our budgets and trying to get through those issues. If we start to change the context of that question and understanding the business need, just my internal trainings, and I'll say like my tactical team trainings, I know what those cost me to be able to do so. And so if you all are providing a service, whether it be here or regionally, I think we have to look at the quality of that service and whether we want that service to continue. And that's really the question it comes down to, because right now Ways and Means, although there was no significant changes to DPSST's budget moving forward, that doesn't mean that that's sustainable. That doesn't mean that right now the requirements are very much outpacing the resources, regardless of where you are in this state. And so I'm supportive of these conceptually. I'll throw on there the absenteeism one. If you're absent, I saw the DPSST is extending all the way up to 72 hours before that they're allowing you to cancel. So this is not unreasonable and things that frankly we are all dealing with as we're trying to make the bottom line. So while I will very much talk about the state's failures to really fund what needs to happen in this state, whether that be DOC, whether that be law enforcement, public safety in general, it's not something that DPSST controls. And I've been in the building testifying for DPSST, trying to get those funds going in the direction that we need them to go. And this current legislature continues to fail us. And so I think this is a reasonable ask right now to ensure that we have some sort of mechanism in place to continue to receive the type of training that we would expect from DPSST. The track itself, I believe the last update from the director was about 2 years out, that it would need a significant change, 2 or 3 years, somewhere in there. And yeah, it is, Matt, because you get to deal with county roads too, just like me. No, I don't ever want to deal with county roads because it's just the weather, the climate, everything else around here. We want that facility to stay safe and useful, because when we want our folks on there, we want our folks to come out and be able to get that training. But I also don't want to worry about the potholes and other things else that are going to cause concerns. So my take on it is that I'm supportive of this. I absolutely see the data. I hear the concerns in the current direction that we're going, with Measure 5 and Measure 50, whether we're looking at property tax, that these concerns are never going to go away. We probably could have predicted these concerns without ever sending out the survey. So while I'm empathetic to many people that answered these questions, this just becomes a prioritization within an agency of where do we want to put our funds and what are we trying to capture, what's our objective. And I think one thing I do appreciate about DPSST is the collaboration to work with other people to solve those problems. There are still ways that you can request to not have to pay the fees. You can request a waiver of those fees. And I think the DPSST probably sides on that waiver more than they side on the fact that you're more than capable of paying this and you don't need this waiver today, but we will grant this today. So that's my 2 cents, because I think you made it an open floor comment session, that I do support the fee waivers. The only thing that I would ask, and I think this is just being fiscally responsible, is that when we do implement something that involves a fee or something else, we also implement a process of evaluating that fee at least on a yearly basis. And as the economy changes or other things change, then if it's not necessary, it can go down as well as it could go up if we continue to see the inflation and other things like that.
Matt Phillips, for the record, I agree with Sheriff Hunter. I guess my concern is that the fee revenue is going to be small and not going to be enough to resurface that tire track, and then I guess the other thing that I've been wrestling with, and I've come to a conclusion on, is when agencies come to train at this facility, I guess providing the facility isn't necessarily a requirement of the state or DPSST, right? So if, like, I'm not going to be able to bring all my staff down here reasonably to use the EVOC track. Sheriff Hunter can because right next door, right? So really, it's the county's need for the facility. So it's reasonable that, if I had to pay to use a site for training in my county, Marion County could do the same. There does need to be some sort of cost recovery mechanism.
Yes, just to amplify your point, like that is a piece of this conversation, I think, is that this campus is in Salem.
Right.
And that directly dictates who gets to utilize it.
Right. Yeah. And yeah.
John Tabor, for the record. Use by agencies for classes not being run by DPSST makes a lot of sense. My concern would be that down the road, this would be fee for training. We have another agency in this state that mandates training and then charges you to attend it. I don't know if you've heard of DAS, but they mandate the training and then charge you for it, which is a frustration even for state agencies who have infinitely deep pockets. Right.
Except for DPS.
No, trust me, we're under the same bunch everybody else is under. But I would ask that the department's careful about going down that road. Fee for usage is one thing. Fee for training is an entirely different animal.
Yeah, I think I can respond to that briefly. I think at least for my own part, but I think to a degree I could speak on behalf of leadership. the feedback we received on this fairly limited scope one, I think certainly put our eye on the fact that like philosophically, the agency does have a mission. And I get a sense of how hot that wire is, right? And not that I'm scared of it, just like genuinely, like that is who we are, right? We have a mandate to provide basic training. This is adjacent to that. We see the distinction.
Right.
This point, I will entertain a motion on the criminal justice fee implementation.
Matt Phillips, just for clarification. Is this a motion to let DPSST continue to have conversations with all the other boards? Or is it actually to proceed? I guess I'm not super clear.
I think functionally from my seat, it would be nice to have an endorsement or non-endorsement on both the facility fee and the regional fee that we would then carry forward to the board. That's what we'd be seeking from Telecom and from Police Policy Committee as well. The board's previously directed us to engage with those parties.
So Matt Phillips, I will make that motion to proceed with both the facility and regional fees and to continue that conversation with the other boards or committees.
And kind of for the record, I will second and just use Chris's word that I will add on endorsement for the implementation of the facility fees and the regional training fees.
We're voting on a motion to approve the criminal justice fee implementation for facility and regional as presented. Chair Hunter?
Aye.
Vice Chair Cameron?
Aye.
Member Aldrich?
Aye.
Member Bowden? Roscoe?
Aye.
Member Mace?
Aye.
Member Phillips?
Aye.
Member Rice?
Aye.
And Member Tate.
Aye.
Thank you, Chris.
Thank you.
We'll move on to basic parole and probation curriculum revision. Jason.
That would be
As I
stepping
look
in for
around for
Jay.
Jason and don't see Jason, Jason became Chris.
Yep, I'm gonna cover for him. He had a conflict. Right. At least this is my last one, so I think I can hold it together. I believe we briefed a corrections policy committee at last session on this concept, but I'll just cover it briefly. We have had the basic parole and probation program and the armed parole and probation program operating in unison since 2019, effectively, when you discount the pilot program that preceded it. While both those programs have been successful, there's been increasing concern about particularly the effectiveness and safety of the 2-week armed program. It is a 74.5-hour program. It is a pretty condensed and skills-heavy block of instruction. During that period of time, students receive 10 sessions of firearms, 4 sessions of defensive tactics, 2 of building search, and 2 of use of force scenarios, plus some additional content layered in there. But those series are the ones where we're seeing the worst outcomes. While students are still certainly learning in those programs, it is a push, and it has become probably the most rigorous and arduous program we've come to offer, which wasn't by design. Right, a 2-week push to go from functionally potentially a 0 to like a proficient officer in those skills is really challenging, particularly when it's structured against the basic parole and probation program. It's just a very weird flow, right? They graduate on a Friday from their basic, everyone's here to cheer for them, and they come back on a Monday and they push through 2 weeks of pretty strenuous work. It also has some secondary impacts. I spoke with OACCD about this at 2 of their prior meetings, almost on the philosophy of the job, if that makes sense, right? By bifurcating those armed skills into this trailer program, we arguably end up at a point where we have basic students that walk away on Friday of their basic with a pretty well-rounded set of skills, and then they just get dumped into this kind of firearms tactical world. And there's a little bit of anecdotal from directors of like, they're seeing a change in their students, right? They're coming back fairly heavy focused on skills, and that shouldn't surprise us, right? Like you remember the last part of a presentation, shouldn't surprise us that students remember the last part of their training. So the recommendation we have here is to merge those 2 programs. That is a substantial change. By merging those 2 programs, it'll change graduation outcomes, it'll change a lot of things. Despite that, OACCD has voted to support the proposal, and really what we're here to talk about today is process. So what we're proposing is a 2-class pilot, much like John spoke to on the value of piloting. This is a program that I think we're not interested in kind of just hard setting, right? Rolling into it cold, it has potential for significant impact on constituents and students. A 2-class pilot should give us the ability to kind of tailor this program. It would offer us a return option in November if we need to course correct on curriculum. But most likely those 2 classes will run and will return next year with a formal recommendation to implement it as true curriculum, which would then trigger rule change and a slew of other issues. So I know that you received summary of hours. The program change does do a little bit more than just insert that program into the basic. There's a few hour changes within content that was within the basic pre-existing that will adjust. And we're going to round the program out to 280 hours, right? 200 plus 74.5 gets us to a point where 280 gives us just a little more latitude to continue to amplify the mandates under Senate Bill 1510 that were set for parole probation officers, and to lay in content like ACAP, airway circulatory anatomy and physiology, statutorily mandated for police. We view it as best practice for all disciplines. So it's a really good opportunity to kind of round that program out and give us an opportunity to run for 2 classes and kind of confirm if we can space and sequence those 10 firearm sessions alongside other instruction. Do we see better outcomes in terms of qualification, better outcomes in terms of safety violations, and better outcomes in kind of those officers hitting graduation with a true kind of holistic sense of who they are as a professional for the state? I'm happy to take questions on it. The only thing I guess I should add, unlike John, who was able to give you hard dates, BPP 92 will start in August. The 2nd class of the pilot is a little bit of a loose placement. Right now, we're thinking it'll probably be in March of next year, but enrollment and budget within community corrections will dictate that. And if enrollment isn't there, maybe to move back a little.
Kind of for the record, I'll just comment a little bit on this. And what's funny is the number 12 that's right after this and the basic corrections firearms work group. So I'm at an interesting position where I agree and I disagree with this. And I'll just let the cat out of the bag. I'm going to agree more than I'm going to disagree. The reason being, I know there's a push for this when it comes to the number of our folks that are, again, attending APP after going through BPP. It's a lot of acronyms. So the APP course itself, the science of learning is frankly zero and detrimental. It's not what we want when it comes to learning, retention, and then transference. And the ability to go from 5 to 7 weeks, but now being able to interleave firearms throughout the whole thing, this gives us much better outcomes, is consistent with our academy studies, that we are producing better people at the end of this, which is what should be more important for us. So it gets us away from a lot of the block and silo, which doesn't work. So I'm a supporter of this. Still frustrated about the correction side, but I think that's a discussion for a different day or number here 12. But I'm a supporter of this. I think this does produce better outcomes, which is what we should want to do as a state and as an academy.
And Matt Phillips, a question I was unclear of. I know this is a pilot, but would the goal ultimately be for all PNP classes to be this 7-week course that includes firearm training? Or would it be you'd offer a couple of these a year and one that's unarmed, which would be really difficult for hiring and training new people? I mean, what was that?
The short answer is yes. The end goal of this, is, if successful, would be that it would become the basic parole probation program, right? However, for a variety of reasons, we would maintain the armed parole probation 2 weeks as standalone. We're thinking it'd probably end up being about a once-a-year offering that would really be there for those legacy officers in the field, right, who graduated with a basic cert, but did not but they are moving into an armed status mid-career. We also have a need to maintain something like that for out-of-state laterals. So there's probably a likelihood that we would keep that legacy program alive as long as need is there. But the goal would be that if the pilot's successful, we would likely be recommending that this becomes the statutory requirement.
So Jennifer Cameron, obviously I'm a parole probation officer and have been for a while. And I support the training. I think it's good at including it in, and I think making a better well-rounded PO, like Sheriff Hunter said, we want success and people to learn and go from there. In the state of Oregon, we're really going towards mandatory arming now for new hires. There's very few counties that are not requiring that anymore. In fact, the state just moved to that. And we will be mandatory, mandatory for new hires now, mandatory for everybody else. Although all of us are armed come January 1st. So I think it's just good that I support it, so.
Okay, I'm gonna make this. Yes, sure, Phillips, I will entertain a motion.
Would you like to make it? I'll just.
Are you sure it's an
Yeah.
entertainment?
I was going to, and then you started talking, so I just stopped. So if you got that motion, go right ahead.
All right, I guess I would move forward with the pilot program for the armed 7-week academy.
On favor, I'll second.
Voting to approve the basic parole and probation curriculum revision as presented. Chair Hunter,
Aye.
Mr. Cameron,
Aye.
Member Aldridge,
Aye, sorry, couldn't find my button.
Member Bowden,
Aye.
Member Frasco,
Aye.
Member Mays,
Aye.
Member Phillips,
Aye.
Member Rice,
Aye.
and Member Tom.
Aye.
Motion.
All right, now officially, thank you, Chris.
Thank you.
All right, we will move on to basic corrections firearms work group report from Marie.
Thank you very much, Mr. Chair. This is Marie Atwood for the record. Agenda item number 12 is intended to provide a final report on the work that has been conducted by the Basic Corrections Firearm Work Group and their recommendations for this committee's consideration. In October of 2024, the board approved the formation of a work group to evaluate whether updates were needed to the firearms training requirements for corrections officers. The work group's main task was assessing statewide needs related to including basic firearms training within the entry-level training and certification requirements, with particular attention to corrections for officers hired into unarmed positions that do not require firearm use or access on a regular basis. After its initial review, the work group recommended conducting a statewide survey to determine how many unarmed corrections officers are employed, and then to better understand whether there's a need for changes or alternatives to the current basic firearms training. So we did those processes. Survey results indicated a strong statewide support for maintaining the firearms training within the basic corrections courses. However, the work group noted that conditions and needs may continue to evolve over time. Copies of the survey report and the work group meeting minutes were included along with the memo from DPSST in your materials for today. So the recommendations that the work group landed on. By consensus, the work group members approved 2 recommendations for Corrections Policy Committee and for the board's consideration. The first, the work group recommends that no changes be made to the basic firearms training that is included within the DPSST and DOC basic corrections courses at this time, which would mean that there would be a minimum of 24 hours of entry-level firearms training for all corrections officers. Second recommendation, the work group recommended that the applicability of basic firearms training for all corrections officers be reviewed again in the future as workforce needs or operational practices change to account for those positions where the use of a firearm or training in firearms may not be as applicable as other individuals involved in corrections work. DPSST's recommendation for today. DPSST supports the adoption of the work group's recommendations. To facilitate future consideration of this issue, DPSST may incorporate evaluations of the firearms training requirements for corrections officers into our regular curriculum review process. Adoption of the recommendations today would formally conclude the existing work group, but again, those revisions and reviews would continue over time in different iterations. So for today, the next steps, if the Corrections Policy Committee approves the motion in the action item, it's included on page 2 of the memo you received, DPSST would submit the report and the outline recommendations to the board for final approval and review in July. I would also like to thank all the work group participants. I know some individuals in this room were participants in this conversation. If there's anyone who participated on the work group who would like to kind of further illuminate any points that the group discussed or discuss things further before we move to the action item, I would invite you to do so now.
Don't do it. I'll make this short. Nick Hunter for the record. So a lot of push towards this work group came from me. And what I want to look at, and it's interesting right now, or I'll say what I wanted to look at. And it's interesting right now looking at 1510, as Jennifer was just talking about, and PMP going to the mandatory armed. That really changes how we want to look at basic parole and probation curriculum. I mean, it has to be part of it because there's an outcome we already know. The push through looking at corrections firearms were and I'll just speak freely, perceptions are different around this state. But we do have a number of corrections officers, a number of men and women that are working in what would otherwise be unarmed positions. They're working within facilities. They don't have a need to necessarily carry a firearm, and several of them don't want to. And so just looking at that pool was part of this. Are we potentially limiting our applicant pools in times when we are actually looking for applicants to come into the corrections profession? And so we are also putting potential strains on agency training. When you have somebody that otherwise does not want to carry a gun and is not ever working in positions where they would need to be armed, then you are still having to take that person to the range and qualify them. And many of those folks may not be able to qualify on the first time. And so you are using a lot of agency resources to continue to do this. It's costing you money for someone that otherwise wouldn't want to carry this firearm. And so I wanted to be careful that we weren't missing that in the discussion because we are limiting this. Many agencies have gone through, I know my agency has, where I have had good corrections folks that have done very, very well. Unfortunately, when they've gone to the academy, they can't pass the firearms. And when they can't pass the firearms and they cannot be certified, I can no longer keep them working at my agency in that position. And that's not, to me, that's not an acceptable outcome. I very much respected the feedback. Julie did a ton of work and had to deal with my revisions over and over again on that survey, trying to capture what we wanted. So I appreciate DPSST's partnership and really trying to come to an answer. And I appreciate where the state is at right now. And the state is saying no. Right now, we want armed corrections folks. And so a lot of the recommendations, I believe that Marie read, are actually the recommendations out of my mouth as to where we came at the end. And the biggest one being that we don't just look at this as the finality. We look at this as something that we will consider moving into the future as times change, job descriptions change, training is changing, things like that. So I'm not upset about the outcome. I think it was the right answer for the current time, and it's just something we'll want to evaluate again in the future.
John Tabor for the record. Our agency is unique compared to the counties. The vast majority of our staff will never work an armed post. We've got 4,500 employees in the department, 3,000 security staff. The vast majority will never use a firearm in the course of their duties. If they do, there's a high likelihood that's going to be a rifle and not a Glock. We've had 3 lethal force incidents in the Oregon Department of Corrections in the last 40 years. They've all been with a rifle. So when I saw the survey, when I saw the conversation come up, I was right on par with you. We've had staff, we've had applicants tell us when they find out that they're going to have to qualify with a pistol, that they're bailing out of the recruitment process. We've lost people in the training phase because they can't get through a Glock qualification. And they get 3 days of training and they're never picking up a gun again. So I hear 100% of what you're saying. I'm glad that the idea is that we're going to continue to explore this going forward. I think that's really important to serve the needs of the various agencies with various needs around the state. So definitely DOC is on board to continue those conversations as we go.
Josh Aldrich for the record. First of all, thanks to this group for all the work. I know there were a lot of people who spent time considering this. While I don't necessarily love the outcome, I do really like the idea, like Mr. Taylor said, about reviewing it frequently. My only recommendation potentially would be that there is an actual timeline put into the recommendation about how that frequency could look. And I'm not making a suggestion for how often that should be, because I do know it's a lot of work, but I don't like open-ended, we'll look at this in the future type of recommendations. I worry that future can always continue to be the future.
Hunter, for the record, Josh, my timeline is my impatience. And so I agree with you. Sooner than later is probably going to be a better time to have this discussion.
For motion.
Either you weighing in or you giving a motion.
Ready to give a motion.
I will entertain a motion,
All
sir.
right, Matt Phillips for the record. I move that we recommend to the board adopt the recommendations made by the Basic Corrections Firearms Work Group.
We're voting to approve the Basic Corrections Firearms Work Group report as presented. Chair Hunter.
Aye.
Extra Cameron.
Aye.
For Aldrich.
Aye.
Member Bowden.
Aye.
For Crosco.
Aye.
For Mays.
Aye.
Member Phillips.
Aye.
Member Rice.
Aye.
And Member Taylor.
Aye.
Motion carried.
We will move on to proposed rule changes for Oregon Administrative Rules OAR 25900800309 and 25900800310, denial and revocation process for professional standards cases involving student dismissals or employment arbitration findings. And we are still with Marie.
Thank you very much. Agenda item 13 presents additional recommended changes to OARs that have been listed, 309 and 310 in the 259 chapter. Both of these rules were included in the comprehensive set of proposed changes relating to moral fitness standards and the process that DPSST uses to deny or revoke certifications that were presented to you in February. So most of what we're talking about for the remaining agenda items today are topics that this group has already discussed to some degree. Since then, staff has identified 2 additional areas where language could be clearer. So these 2 particular changes are going to be the only new things to the table on our moral fitness guidelines. I'm going to walk you through each of these today and the proposed amendments that will help DPSST align its administrative rules a little bit more closely with what their original intent was when drafted. So the first issue involves how we handle student conduct at the academy. Right now, the administrative rule governing student investigations and dismissal gives DPSST really broad discretion to open up a professional standards case based on any violation of a student conduct standard, even if the student wasn't dismissed from the academy as a result. This is a very broad scope of discretion and was way broader than was intended when the rule was originally created. It creates also an element of confusion about who within the agency is responsible for the determination of whether a professional standards case should be pursued, because student investigations and dismissals are handled by the training division. Professional standards cases are handled by the professional standards division. It's the difference between the training and the post sides of the house. So in order to make the rule reflect what its original intent was and to clarify kind of whose duties and responsibilities are involved, we're proposing this additional set of amendments. The proposed change would limit the discretionary cases, so cases that we file based on student misconduct, to situations where a student is dismissed under OAR 259-012-0035 for a conduct violation. So if a student commits an act of misconduct while at the academy, but it doesn't rise to the level of a dismissal, professional standards division wouldn't touch it. The professional standards case would not be pursued. So this clearly would help place the responsibility for determining whether a student conduct violation occurred with the training division instead of with our compliance staff, which makes sense because the training division conducts the full investigation into the student conduct. If and only if the training division finds misconduct occurs, recommends dismissal as the appropriate disposition, and let's say a student decides to appeal that dismissal determination, if the director affirms that dismissal, only then would the issue rise to the level of professional standards case. It narrows those grounds for opening our cases to very sort of specific window. If a dismissal is overturned during that appeal process to the director, then the conduct would not come to the professional standards team. And I think that's been the root of a lot of the confusion is sometimes the training division's ultimate disposition recommendation is not what the director decides to do, depending on mitigation information that's received after the initial investigation occurs. So our compliance division would only see a case and only consider opening a case if the dismissal is upheld and formally brought to action by the director. So this brings the rule back in line with its original purpose and helps remove that ambiguity. Any questions about this proposed change? Okay, great. The second issue is something totally different, but it relates to employment arbitration. So under the current administrative rules, our handling of a professional standards case tends to be inextricably tied to an arbitrator's findings if a person is terminated for misconduct and proceeds with an arbitration process. This can be a little bit difficult and frustrating because for the most part, if someone's terminated from agency employment, it's based on an agency policy violation of some kind. And then an arbitrator's findings involve a determination of whether the agency policy violation finding aligns with or kind of rises to the level of employment law standards for termination. DPSST standards in our administrative rules are a totally separate set of guidelines for moral fitness for individuals in the public safety world. So as we work through cases, this disparity and disconnect has made it very clear that the rule as worded unintentionally limits the independent authority of DPSST to take action on moral fitness grounds where employment law wouldn't be applicable. So it would return that authority back to the department to propose moral fitness findings to committees such as this one and ultimately to the board, and removes those kind of prescriptive outcomes that arbitration processes impose. Arbitration findings on our current proposal would still be considered, but they are not mandatory for DPSST or the committees or the board to follow. So in other words, an employment decision such as reinstatement or an arbitrator's review of the underlying facts will no longer control the department, the policy committee, or the board's findings on moral fitness grounds in the way that they do under the current rule. So a couple of key points about this rewording or revision, I should say. DPSST still can and likely will in most situations stay a case while an arbitration proceeding is pending. That's consistent with what we do, for example, when someone's charged with a crime. We don't proceed with our case to the policy committee until the criminal case is resolved. That would be consistent with what we're proposing for arbitration as well. So until an arbitration finding is made or the process is complete, we would likely stay our case in case any additional information arises. We want to bring to the committee all of the details we possibly can. Furthermore, once an arbitration is complete, we will continue to review that case under our usual processes as outlined in the rest of the OARs in section 310. If an arbitrator orders reinstatement, we will treat those cases as a discretionary case, just like any other moral fitness-based case. It would put them back in alignment with cases where maybe someone didn't get terminated, but committed the exact same act of moral fitness violation. As it's worded now, strangely, cases where someone is not terminated but commits a moral fitness violation would go to the committee. But cases where someone is terminated for the exact same conduct, but proceeds with arbitration might escape the committee's review altogether. So this would put those types of cases back into alignment. Any questions about that proposed change? Doing a lot of talking. Okay, so DPSST for today recommends approval of these two rule change proposals. The memo that we included in your materials includes a fiscal impact statement, or probably better described as a lack thereof. There were no unique fiscal impacts identified by either of these proposed changes. Anytime we're talking about denial or revocation, right? In theory, there's a fiscal impact to someone who is either employed or no longer employed, or an agency who is gaining or losing an employee. But this or these two proposed changes would not shift the weight of those outcomes at all. So at least by our review. Any fiscal impact associated with denial or revocation under these circumstances already exists under the current rules. So in terms of process for today and moving forward, if the policy committee votes to approve these rule changes, we would submit the proposed rule change to the Secretary of State. Afterwards, a public comment period would follow. And then after that public comment period, depending on whether we receive any comments, we would combine the rule changes, the initial round of public commentary, and return back to you for a final review based on any further revisions or kind of reconsideration that might arise between now and then. And hopefully the final approval to submit the changes would occur in August for the board. If there are no other questions, there are action items on page 5 of the memo you received in your materials, or further discussion is also invited at this time.
Okay, for the record, so we're making a recommendation as the Corrections Policy Committee that all the policy committees are going to be asked the same question, and then this is going to go to the board for that final recommendation.
And then to the Secretary of State for the public comment period.
Well, Matt Phillips, I'd like to say, great report out on that. And I really like separating ourselves from the arbitrators, because we already know that they're not following the law as it relates to the relatively new law enforcement standards and conduct. So that can be problematic. So I guess the first issue is a consensus. And the packet says.
Yeah, consensus.
Or we can move on to a motion and vote.
I think we can just, correct me if I'm wrong.
So typically we would do, hold on, let me pull up page 5.
So the action item number 1 is consensus discussion. Approve or omit the fiscal impact statement. Everybody's.
So Marie Atwood, for the record, having identified no unique fiscal impact for these proposed rule changes, we would first see if the committee has any difference of opinion or might identify some fiscal impact that we hadn't considered. Otherwise, we would ask for a consensus on that issue and then vote on the proposed rule change.
Okay, so we are looking for a consensus to approve or amend the fiscal impact statement prepared by staff. Is there a consensus to approve or amend? Okay, sorry, I did. There was Jeopardy. Wasn't a question first. Okay, with consensus then. So now I'm looking for a motion to approve filing for OAR 259-008-0300 and 259-008-0310 as proposed rule changes for public comment.
John Tabor, for the record, so moved.
Matt Phillips, second.
Okay, we're voting to approve the proposed rule changes for OAR 259-008-0300 and 259-008-0310 as presented. Chair Hunter?
Aye.
Vice Chair Cameron?
Aye.
Member Aldridge?
Aye.
Member Bowden?
Aye.
Member Frasco?
Aye.
Member Mays?
Aye.
Member Phillips?
Aye.
Member Rice?
Aye.
And Member Tate.
Aye.
Motion
We're moving on to 14, review of public comments for proposed rule changes for Oregon Administrative Rules OAR 259-008-0005, 259-008-0290, leaving out the first 6, 0300, 0310, 0320, 0330, 0340, and 0400, amending public safety professional certification denial and revocation standards and processes, again, presented by Marie.
Thank you so much. So this agenda item, as I referenced before, is a set of proposed rule changes for our moral fitness guidelines that we've already at a previous juncture taken to each committee, gotten feedback, revised, been through the public comment period, and now we are returning to the committee. So the agenda item facilitates the review of comments collected for the proposed rule changes to moral fitness standards for denial and revocation processes for criminal justice and public safety professionals. We presented the original proposed rule changes to the committees in February. Each policy committee provided feedback that we collected. And following those meetings, DPSST then sent the rules through to the Secretary of State and opened a public comment period. That period was from February 26th through March 31st of 2026. We received one written comment, which is included in your materials. The memo we drafted for the committee's consideration today is divided into two parts with supporting attachments for reference. The attachments include a copy of the written comment and a copy of the proposed rule changes that you saw back in February. Part one of the memo simply summarizes the comments provided by the committee members in February. So there's no further action needed on that. You were part of those discussions. We are currently in the process of revising rules based on both committee feedback and on the public comment. However, before we do that, we want the committee's input on the public comment itself before we return back to a later review in August and to the board for final approval. So that brings us to part two of the memo, which covers the single written public comment we received. Staff summarized the comment and provided our interpretation and analysis of it in sections A through F. The action item on page 4 is what's before the committee today. It's just the summary and analysis section. The committee can either adopt DPSST's recommendations regarding the comment, which would mean no additional changes beyond how we have already determined we would respond to the concerns that were raised. Or if you feel like any part of the written comment should require further discussion, should lead to a revision in our proposed rule change, or anything like that, you can make those discussion and motion here today prior to our August final review. So at this point, I will turn it back over to the committee to discuss, if desired, the written comment that we received and DPSST's proposed response, or how we would handle the comment and our recommendations.
Yeah, Phillips, just for the record, there's a lot here, especially on that public comment. But for the most part, I would like to go with the DPSST recommendation, but actually fully. There was one section where additional consideration was maybe suggested, but I'm satisfied with where we're at.
Kind of for the record, I would concur. I think a lot of the public comment from the one public comment that was very involved.
Yeah.
A lot of it became sort of subjective perceptions. I thought DPSST did a good job of addressing those questions that were put out there. And unfortunately, this was reading one of these public comments where some things seemed to be very clearly outlined, yet the public comment wanted to make a statement so that they could be on record making a statement about a statement that was clearly already answered to them. I can't make it any more confusing than they did, but I do appreciate DPSST's response. So before we go to a motion, I will put it to the floor if there's any other to the table. If there's any other comments before entertaining a motion. Okay, so I would entertain a motion to make a motion to adopt DPSST's recommendations as noted in sections A through F.
Matt Phillips, so moved.
John Tabor, second.
We're voting to approve the review of the public comments for the proposed rule changes for OAR 259008 with serial endings 0005, 0290, 0300, 0310, 0320, 0330, 0340, and 400 as presented. Chair Hunter.
Aye to all of those.
Vice Chair Cameron.
Aye.
Member Aldridge.
Aye.
Member Boda.
Aye.
Member Brasco.
Aye.
Member Mays.
Aye.
Member Phillips.
Aye.
Member Rice.
Aye.
And Member Two.
Aye.
Motion carried.
Thank you, Lon. All right, last but not least, agency updates. It has no name, but since you're still sitting right next to me, I'm gonna guess that's you.
Yep, thank you so much. Marie Atwood for the record. I'm appearing on behalf of Director Castle and Deputy Director McAlpine today with just a few agency updates. So beginning with our requisition process for a learning management system, the LMS project has maintained rapid progress over the past couple of months. A lot of momentum since we brought our project manager on board. We also have assembled a project team within the agency to help us identify what our needs are down to like the most kind of molecular level, so that we can ensure whatever product we get approval from DAS to acquire really does fulfill what we're asking it to do. So to that end, a lot of legwork has gone into this and a lot of agency effort. And we have finally gotten state CIO, DAS, and EIS approval to proceed with a stage gate 1 endorsement. What that means is that we're out of just the bare initiation phase of we would like an LMS and what now, into the actual identification and procurement stage. So that's a really big benchmark for us to have reached in a very short amount of time. We are also pursuing a policy option package to add some support staff for kind of future thinking toward when we adopt and acquire an LMS, we're going to need people to run it, to train others to use it, and to kind of maintain it. So that is our LMS update for now. Another big agenda item for the agency right now is accreditation. So as you know, DPSST is fairly unique. We're one of only a handful of both academy and post statewide entities that train public safety and engage in compliance across the nation. Kathy McAlpine is spearheading our intent to become an accredited academy and post through IADLEST. So first, we are going to proceed with our training or academy level and then move to standards and certification level accreditation. But we're keeping those separate because it is an enormous amount of work. We have proceeded right now with getting a whole lot done through the self-assessment process, which basically requires everyone in the agency, from the individual contributor level to small teams, to units, to divisions, to evaluate all that they do for best practices and evidence-based approaches in law enforcement training. The next thing that'll happen once we're done with that sort of self-assessment is an on-site assessment or audit from IADLEST to ensure that what we report back to them in our request for accreditation is actually reflected in what we're doing on day-to-day. If we are able to achieve this, it would be a great milestone for us and for Oregon because we are already pretty well recognized for the quality of training we provide, but this would be a really excellent stamp of approval to kind of show nationwide. We would have to proceed with this assessment process every 3 years if it is granted. So this will hopefully become a pretty regularized part of what we do here. Next update topic, budget. So as we've talked about in various corners of today's meeting, budget is on the forefront of everyone's mind who works in either local, county, or state government right now. I will say that we are in a much better budgetary position right now than we thought we would be 6 months ago. So we've moved from sort of a doom and gloom mindset to a cautious optimism mindset. We have been informed that we are a no harm status by the state, and we are in the black, but only barely. So our goal, for example, is to end the biennium with $5.5 million overflow. Our projections right now put us at 6.2, but considering there's about a $3 million cost of running business every month, right? Even a very, very minor inconvenience could change that quickly. So we're still keeping budget at the forefront of all of our agency decisions. We're conducting some cost studies right now in collaboration with the CFO and LFO on particularly inflation budgeting, because there are some things that no matter how many paper clips we count in the agency, some things are out of our control, or like changes in the federal government funding can dramatically impact what we do here at the state level. So budgetary news is certainly more optimistic than it had been within the past calendar year, but yeah, we have to maintain a close eye on everything we're doing here at DPSST. One thing that we are doing that we have good news about is a whole lot of campus and facilities maintenance. So you may have noticed when you came to campus today that there's a big roofing project going on over at the B building that started about 3 weeks ago. We are in late June, early July, going to proceed with a massive repaving project for our parking lot, which will be wonderful. We're going to try to do that during the down weeks so that there's not a ton of people around. We are also going to be replacing our gate, our upfront gate. There was an inordinate amount of deliberation that went into choosing the right type of gate, but we do feel very confident that we've got a good selection made. But obviously those projects are pretty cost intensive as well. We did get our memorial lighting replaced out here just out front, which looks lovely when it's dark outside. And we had the opportunity to have our memorial, the fallen officer memorial proceedings, I guess, last week, which was a really wonderful ceremony on a beautiful day for once, not 100 degrees and also not pouring down rain. So I think that's all I have from the leadership level for general agency updates. My own personal update from professional standards is that we are going to be proceeding with our work groups for training maintenance standards very soon. We just recently got approval for those. We are actively searching for participants. So we have already several participants who have volunteered to be on our maintenance work groups from our various policy committees, but we really want it to be a robust discussion. So if you know anyone who is not involved already in a policy or board position who you think might have a really great perspective or a good voice for our maintenance requirements work groups, please let them know. Encourage people to apply. We send the information out via our kind of gov delivery notices, but not everyone is always paying a ton of attention to those. So any help we could ask you for in terms of recruiting individuals to be on those groups would be really appreciated. That's all I've got.
So meetings being added while we're here. I'm just going to stay here, so I'm going to stay here and talk for a while. Nope. We'll just make this one really quick then. Thank you, Marie. Just one, thank you to DPSST staff. Two of the cases we had today were cases that we sent back to you for more info. But for example, the Andre Brown case, that info was really, really important in understanding the context of that situation. Same with Mr. Pratt. That was really necessary to realize that there was nothing necessarily there for us as a body to deal with. So thank you for the work. To everyone else in this committee, thank you for the preparation, the work, the contributions. The only thing that I will ask, I would like to entertain motions from some other people. So please don't be afraid to speak up. Participate. Like Marie was just talking about. You're all here for a reason. You're all doing a fantastic job. I realize this is giving up time, not just here, especially in preparation for these and things like that. But we want those opinions and we want people to be able to share. So please feel free to share more motions and I'll try not to make it so confusing.
It's invited to me today.
No, Matt and I were playing eye contact the whole time, trying to outguess each other. So we're fine. Yes, the May 5th fallen officer, and really was a nice event. Remember, we've got the same thing in June for the fallen on firefighters. It's coming up. I can't remember exactly, June 12th or 15th, somewhere around there.
What was it?
I believe it's 15.
15th.
15th.
I'm sorry, 16.
16th. I was really, really close. Besides that, I don't have anything else other than appreciate everyone's time and commitment to what is really, really important work here and what it means to DPSST and this profession. So with that, I will adjourn this and thank you very much.
You should.
Oh, are you waving, Josh, or you got something to add? Okay, you're just waving.
Thank you.
Bye.